Carlos was heading west near the Big I in Albuquerque. He was going about 5 over the speed limit when another driver ran a red, T-boned him. Carlos ended up in the hospital with 2 broken collarbones and 2 herniated discs. Now, when the other driver's insurance company called, they told him he was partly at fault because he was speeding. And because of that, they said his claim was worth significantly less. I'm Damon Hudson, and some people call me Attorney Damon with Hudson Injury Law. What that adjuster told Carlos is not how New Mexico law works, and understanding this one rule could be worth thousands of dollars to you. So here's what most people don't know about New Mexico. We have what's called a pure comparative fault system, and it's different from the majority of other states in the country. Even if you're partly at fault for an accident, you can still recover damages. Not even if you're just a little bit at fault. Even if a jury determines that you're 99% responsible for what happens, you could still collect on that remaining 1%. Let me explain why this matters with real numbers, right? Now let's say your total damages are $100,000. Medical bills, your lost wages, your pain and suffering, everything adds up to $100,000 or so in damages. And a jury determines that you're 30% at fault because you were going a little too fast or you didn't brake soon enough. In a pure comparative fault state, you would recover $70,000. That's $100,000 minus your 30% share of fault. Now, in many other states, if you're more than 50% at fault, you get nothing. Texas works that way, Colorado works that way. Under New Mexico law, your damages get reduced by your percentage of fault, but they never disappear entirely. This principle was established by New Mexico courts going back decades. It was codified in the New Mexico Statutes 41-3A-1. Now, why am I telling you this? Because insurance companies use fault as a weapon against accident victims here in New Mexico. They know that most people assume if they were partly responsible for an accident, they have no case. And adjusters lean into that assumption hard. They'll say things like, well, you were speeding, or you should have seen that coming. And they hope that's enough to make you give up entirely or accept a lowball offer. I've seen that other side of that table. I know exactly how that conversation is designed to go. And the fact that it works on a majority of unrepresented claimants is exactly why I'm making this video. If an adjuster has ever used your partial fault against you, tell me about it in the comments. I hear about these stories all the time from clients. Let me give you another scenario so this really sinks in. Let's say you were making a left turn and you misjudged the gap. The other driver was going significantly over the speed limit, and that's what caused the severity of the collision. The insurance company argues you're 60% at fault because you initiated the turn. In most modified comparative fault states, you'd be completely out of luck at 60%. You get nothing. In New Mexico, you'd still recover 40% of your damages. Now, if your case is worth $200,000, that's $80,000 in your pocket you would absolutely not have gotten in states like Texas or Colorado. That's not a small difference. That's life-changing money for most people. Just because you can recover doesn't mean the insurance company is going to make that easy, though. They're going to argue that your percentage of fault is as high as possible to reduce what they owe you. If they can get a jury to assign you 70% fault instead of 30%, they just saved themselves $40,000 on a $100,000 case. So the fight isn't just about whether you have a case. It's about what percentage of fault gets assigned to you. In many cases, fault allocation is a point of dispute in the negotiations. If the case goes to trial, the jury decides based on the evidence, and the adjusters don't get to make the call for you there. That's why documentation matters so much. Police reports, witness statements, traffic camera footage, dash cam video, road condition reports, all of that helps establish what really happened. And that can push your fault percentage down significantly. That's where having a personal injury attorney who understands New Mexico's comparative fault rules makes a real measurable difference. I always tell clients, don't let the insurance company tell you what your fault percentage is. That's not their call to make. That's either a negotiation between attorneys or a decision that a jury makes after they hear all the evidence. The adjuster sitting in office somewhere, say Des Moines, does not get to decide you were 40% at fault and cut you a check accordingly. Under New Mexico law, you have the legal right to challenge that number. When a case goes to trial in New Mexico, the jury gets what's called a special verdict form. It's kind of like a fill-in sheet. They have to answer specific questions, and they note what the damages are and what percentage of fault belongs to each party. The evidence that goes into that decision includes everything. The speed of both vehicles, road conditions, traffic signals, witness testimony, expert reconstruction analysis, whether anyone was distracted or impaired, all of that can shift the fault number in your favor. Most New Mexico personal injury cases settle before they even reach a jury. But the possibility of a jury making that fault determination is what drives insurance companies to negotiate fairly. If they know your attorney has built a strong enough evidence package that shows their driver was primarily at fault, they're not going to gamble on a trial. They'll negotiate numbers that reflect reality. But if you don't have an attorney and you don't have the evidence organized, they'll just assign you a number and cut you a smaller check. Here's another thing the insurance company doesn't want you to think about. The percentage of fault they assign you affects your pain and suffering claim too, not just your medical bills and lost wages. If your total pain and suffering component is, say, $50,000 and they inflate your fault to 60%, that's 30% gone from the category alone. That's real money for somebody after an accident. It affects whether you can pay for treatment and cover your mortgage while you're recovering. I've had people not even bother calling me because they assumed they caused the accident. They figured that because the other driver said it was their fault, or because the police report listed them as a contributing factor, they had no options. Often people still have options. Depending on the facts and coverage, there may be real money to recover. Because partial fault in New Mexico's comparative fault system is a reduction, it's not an elimination. I've seen cases where the insurance company told the claimant they were 70% at fault and the claim was basically worthless. After we got involved, we gathered actual evidence. We brought in an accident reconstructionist, and then we challenged their assumptions. That number dropped to 20% on a $150,000 case. That's the difference between $45,000 and $120,000. Same accident, same injuries, just a different percentage of fault because somebody fought the number instead of just accepting it. Now, I have a video on what happens when you don't fight back and you accept that first offer too quickly. If you've been through that, it's worth watching. So if you've been in an accident and you're thinking you can't do anything because you might have been partly at fault, hear this clearly. You definitely still have a case. New Mexico's pure comparative fault law is one of the most favorable in the country for accident victims. Don't let anyone convince you otherwise before you've talked to a personal injury attorney who actually knows the rules. One phone call. That's all it takes to find out where you actually stand. If you want to see how insurance companies use these tactics, like fault assignment as a part of a bigger playbook, go watch my video on what they actually do with your claim from the moment you file it. I lay out the whole system there. Subscribe so you can catch the next one. Hudson Injury Law, 505-416-4150. Thanks for watching. Have a great day.